All right, thanks everyone for joining. It seems like the number of attendees started to level off. We appreciate your being here. We appreciate your joining us. And I'm gonna turn it over to the CCJ Director, Peter Zimroth, to welcome you all.
Welcome everyone, and thanks for joining us. My name is Peter Zimroth, as you heard, and I'm the Director of the Center on Civil Justice at the NYU Law School. For those of you who are new to the center's events, our center is dedicated to the study of the civil justice system in the United States and how it can best fulfill its purposes. The center's mission is to study and improve the United States civil justice system, and we have no other agenda. Some of the most distinguished judges, lawyers, and scholars in the country sit on the center's board, with roughly an equal number of plaintiffs and defendants' lawyers. Today is the fourth and last panel in a series of events on the new face of antitrust. We are putting on this event in conjunction with Cravath, Swaine, and Moore. Cravath partners Evan Chesler and Catherine Forrest were instrumental in the development and planning of this series, and I want to thank them and the rest of the Cravath team. Thanks also to the other panelists from whom you will hear shortly, and finally, thanks to David Siffert, who is my deputy and Director of Research and Programs at the center. A few preliminary announcements before we begin. This event has been approved for one CLE credit in the area of professional practice. To receive the credit, you will need to submit a form that we will email to each of you within the next day. The form will ask for a code. This code will be given during the panel. Please write it down. We will also be fielding questions at the end of the event. David, how did we decide that we're going to do the questions?
Anyone who has a question can enter it. There's a Q&A box at the bottom of the screen, and you can enter your question there.
Okay, and so today's panel addresses the issue of healthcare consolidation. The moderator is Daniel Francis. Daniel is a Furman Fellow and the Emile Noel Fellow at NYU School of Law, where he writes about competition and public and private practices that shape it. Before joining NYU, Daniel served as Deputy Director of the Antitrust arm of the Federal Trade Commission. Daniel previously served as a fellow, lecturer, and researcher at Harvard Law School and spent 10 years in private practice. Daniel holds 3 degrees in law, a first law degree from Trinity College in Cambridge, a Master of Laws degree from Harvard, and a doctorate of law from NYU Law School. So please welcome Daniel, who will introduce the rest of his very esteemed panel for today's event.
Peter, thank you for that very kind introduction, and thank you for giving us a space to get together and talk today about healthcare consolidation. It's a pleasure to welcome this very distinguished panel to talk about competition in healthcare and some of its pathologies and complications. I'm going to introduce everyone very briefly so we can jump into the heart of the discussion. Norm Armstrong is a partner at King & Spalding, a very distinguished antitrust lawyer in private practice. He chairs the firm's antitrust practice. And before joining King & Spalding, Norm held the same position you just mentioned as my most recent home, Deputy Director at the FTC Bureau of Competition. Evan Chesler is the chairman of Cravath and an adjunct professor at NYU School of Law. He has previously served as the presiding partner and head of litigation at Cravath. Robin Feldman is the Arthur J. Goldberg Distinguished Professor of Law and the Albert Abramson Distinguished Professor of Law Chair, and the Director of the Center for Innovation at the University of California, Hastings School of Law. Scott Hemphill from NYU is the Moses H. Grossman Professor of Law, and he's the co-director of the Engelberg Center on Innovation, Law, and Policy here at the Law School at NYU. And before joining NYU, Scott was with the New York Attorney General's office, where he ran the Antitrust Bureau. Finally, Mark Seidman joins us from the Federal Trade Commission, where he's the Assistant Director in charge of the Mergers 4 division. He's previously held a number of other roles at the agency, and he comes to us as an enforcer specializing in the areas that we'll be talking about today. So let's start our discussion at about 10,000 feet. So obviously the focus of today's discussion will be antitrust, competition law enforcement, mergers, associated practices. But antitrust isn't, of course, the only tool in the kit. What are the most important non-antitrust factors in the view of our panel that affect competition and consumers in healthcare markets? Let's start with Robin.
Thank you very much, and thank you for that kind introduction. Any discussion about pharmaceutical competition can't help but include patents. After all, patents are the main vehicle we choose for incentivizing innovation. We allow companies to exclude competition for a limited period of time. Today, however, patents are also at the heart of strategic behaviors that drug companies use to extend their protection. They do this by piling patents and other exclusivities onto the same drug, or by making slight modifications to the drug's dosage or delivery system or some other aspect, obtaining new patents, and then moving the market to the new and newly protected formulation. Patents also feed into the rebate system that can help brand drugs maintain market share. Brand companies can use volume discounts so that cheaper competitors cannot gain much traction in the market once they do enter. The brand says to an insurance plan or its agent, "We'll give you a good rebate if you keep our cheaper competitor off the formulary, or at least limit them in some way." So where does a brand company obtain the volume to engage in these volume rebate strategies? It's the volume a brand company developed during the period that the drug is protected by patents and the brand's the only game in town. So when the generic tries to enter, get a good position on an insurance reimbursement formulary, brand's already there with the volume to engage in powerful rebate strategies. And of course, these concerns play a role in consolidation. When companies consolidate, they have the ability to bundle rebates across different drugs. Here's an example outside of the consolidation context. A few years ago, Sanofi paid about $61 million to settle an antitrust bundling suit. The suit alleged that when a competing company planned to enter the market to compete against Sanofi's pediatric meningitis vaccine, the company charged prices up to 34% higher for its vaccines unless buyers agreed to purchase all of Sanofi's vaccines exclusively. In other words, you will have to pay dearly for vaccines for which there were no alternatives unless you exclude the ones that do have competition. In short, patents are a key concern for a range of issues related to consolidation, competition, and innovation, and they're important to keep in mind when we talk about this topic.
That's a really helpful overview. Thank you. Mark Seidman.
Thank you, Daniel, and thank you to NYU and the Center on Civil Justice and Cravath for hosting this panel. Before I start, I need to give the standard caveat that I am speaking only for myself today, and my views do not necessarily reflect the views of the commission or any individual commissioner. I see Daniel and Norm smiling as they've given that caveat many times, I'm sure. Today, I know we're going to spend a lot of time talking about antitrust enforcement and the effect of antitrust enforcement on healthcare provider quality, prices, cost, availability, and certainly that that enforcement focuses on mergers that could violate the Clayton Act or conduct that could violate the Sherman Act, and this enforcement is crucial to maintain the proper function of healthcare markets. But healthcare markets are complex, and there are many layers to the markets. There's complementary aspects of them that fit together, and there are other regulations that can affect markets beyond the antitrust laws, and they can affect the behavior of the markets. They can affect the costs and the prices that consumers ultimately pay. And there are a few examples of those. And first, thinking about the state regulatory framework, there's a couple of things that jump to mind. One is a fairly common practice among states, certificate of need regulations. This is a process where a state will determine, will have a regulatory infrastructure to determine when a healthcare provider can enter or expand. And the details can vary among states, but the general idea is if, for example, I want to build a new hospital, I need a permission from the state. I won't purport to have a, I won't purport to opine on the broader net effect of these type of regulations. That's a big picture health policy question. But from a competition perspective, they can have a pretty clear negative effect, because in practice, what happens is the certificate of need process provides a platform for competitors to block entry. If I'm trying to build a new hospital, the existing hospital can object to my certificate of need, and they typically get a hearing and an opportunity to either slow down or stop that entry. And we've certainly seen that happen. And I think what's actually visible may only be the tip of the iceberg, because there are likely entrants potential entrants who don't even bother with the process because of the daunting prospect of the certificate of need gauntlet that they'd have to go through. Similarly, we've also observed states with regimes for certificates of public advantage. This more directly affects competition and directly implicates antitrust. The idea here is for states to implement a regime that takes advantage of the state action doctrine and provides a forum for hospitals to merge in a way that would circumvent the antitrust laws if typically it's the State Department of Health that would approve such a merger. The commission and commission staff have routinely opposed the implementation of these kinds of laws and the actual the adoption of these laws and the implementation of these laws. And I think this has a more, these are less common than certificate of need regulations, but they have a more direct effect on limiting competition, because quite frankly, you would only pursue a COPA, the shorthand for Certificate of Public Advantage. You'd only pursue a COPA for a merger that pretty clearly implicates the antitrust laws and would pretty clearly raise competition concerns. And we've been involved at the FTC in several of these COPA reviews at a state level. And one big misconception that I've observed is that there is a sense among stakeholders in the communities in considering these types of certificates that, well, if it doesn't work out, we can just withdraw the certificate and expose the hospitals again to antitrust enforcement, and anything untoward that they're doing can be taken care of through antitrust enforcement. And that's a big misconception, because mergers are much more permanent than that. And the harm from an anti-competitive merger, the higher prices, the reduced quality, the limited access that can all result, is not necessarily in itself an antitrust violation. And the prospect of going back in years later and trying to break up a merged hospital system is a daunting prospect, to say the least, and not one that is easily done or really is really feasible, and not one that ultimately might inure to the benefit of patients, because it's so disruptive. So those are a couple examples of state regulations that, while not particularly antitrust regulations, can really affect how competition works in the healthcare industry. There are other market practices also that can affect costs that really don't implicate competition, but it's important to consider if you're trying to answer the big picture question of why are healthcare costs so high and why are they going up. A good example that Congress just dealt with, or at least attempted to deal with last year, is the practice of surprise billing. Congress passed a law last December to try to eliminate this practice. This happens when a patient visits a hospital that's in their healthcare network, but lo and behold, after whatever procedure, they end up getting a bill from a provider within that hospital who it turns out is outside of their network. Say they go in for surgery, the hospital's in network, the surgeon's in network, but it turns out the anesthesiologist is not, and they get a large bill in response to that. So that practice has been one that's a little bit higher profile. It's been written about, it's been noticed, and it's something again, hopefully Congress has dealt with that particular problem, but I raise it as an example of all the little sort of corners and crevices in the complex healthcare market that these kind of practices can, where these kind of practices can hide and really drive up costs, really drive up prices. Antitrust enforcement is an important part of trying to control healthcare costs, but it's not the only thing that's affecting healthcare costs. Pardon the military metaphor, but in my view, I think controlling healthcare costs is much more trench warfare than shock and awe. It is a bit by bit, small problem by small problem type of effort. And antitrust enforcement is certainly an important part of the arsenal, but there are issues beyond competition as well.
Mark, on a couple of occasions there, you mentioned hospital mergers as potential sources of lost competition and harm to consumers. And obviously, when a hospital merger gets litigated, it's headline news, and everyone in and around the antitrust healthcare community pays a lot of attention. And this is a very interesting time for merger litigation, as for the first time in a while, the FTC was defeated in a challenge to a hospital consolidation in Philadelphia. This was the proposed and now impending transaction between Jefferson Health and the Einstein Healthcare Network. Norm, what does this decision kind of mean for merger enforcement? Does it have broader implications? How do you react to the Jefferson-Einstein decision?
Well, first of all, thank you, Daniel, for inviting me to be a part of this panel and NYU and the Center for Civil Justice. I suspect, and I know Mark can talk about this from the government side. First of all, I don't think this is going to change anything from the enforcement side of things. As you mentioned, they were on an impressive winning streak. I think for almost 15 years, they had not lost a hospital merger challenge. So I don't think one loss is necessarily going to impact their enforcement. Or making them less aggressive than an enforcement. I also think it's important to look at it from the perspective of the commission and in this administration, right? I mean, obviously, I think earlier today, Lena Khan's was a confirmation hearing. But if you look at it from the commission perspective and what we're likely to see in terms of the bench, in terms of the commissioner lineup, I think we're going to see pretty aggressive enforcement, or at least as aggressive enforcement as the last administration, if not greater. So I suspect that we will continue to see aggressive enforcement from the government side. In terms of the private side, I think that, from parties' perspectives, this could embolden them to fight more with the commission if the commission were to want to challenge a transaction. Obviously, as you mentioned, a lot of our clients have looked at this case pretty closely. The judge seemed to really struggle in this case with the geographic market and trying to understand, what the right evidence is and what weight to give the right evidence. On the one hand, I think the judge kind of agreed with some of the arguments that the government made here in terms of market, geographic market. But on the other hand, his decision suggested that it did not comport with the commercial realities of the marketplace, and in particular looked at the testimony from insurers. There were four insurers in the matter, and the judge had mentioned the fact that the government seemed to not focus on two insurers who were against the transaction or not supportive of the transaction, and focused on only the other two. And the largest one, I think the judge mentioned, had a motive for complaining in the transaction. So, I do think that this could embolden some parties to fight. I think they're going to look, closer at insurer testimony. I mean, one question we always get when we're representing clients is, what about insurer testimony? How much weight do I give it? What if they're divided? What does that mean for the FTC? What does that mean for a judge? And so I do think that that's going to play into this. I think another interesting thing to mention regarding the matter too is, as we all know, I think either at the end of the year, last year, or the beginning of this year, the state AG's office removed its opposition to the transaction in exchange for an agreement where Jefferson would invest significant amount of money in Einstein. The agreement really didn't seem to go to the merits of the transaction. However, I think it was important, and I suspect, even though I don't know this for a fact, obviously, but that it played a role in the commission's decision not to move forward on appeal. And again, another question you often get from clients is, what role does the state AG play? How important is the state AG? if we can convince the state AG that this to support our transaction, does that mean the FTC goes away? Does that mean we will win in litigation? So, I think that all these things suggest that it's possible that clients will want to be emboldened to fight, but I don't see it changing anything from the government side.
Thanks, Norm. I want to bring Scott in, but before I do, Mark, obviously Jefferson Einstein is somewhat close to your heart, and I know you'd have a lot to say about it. Any reactions or additions to Norm's perspective?
So yeah, I agree with a lot of what Norm said. I think certainly in terms of the decision's overall effect on the level of enforcement people should expect from the FTC. I agree. I don't think it's going to affect the aggressiveness of our enforcement. It was a very fact-specific decision. As Norm noted, it seemed to turn as much as anything on the court's credibility findings of the insurer witnesses. And, we could talk about that for an awfully long time, but, at the end of the day, that's up to the judge. But that's a very fact-specific aspect of the decision. Another interesting part of the decision that is important to take note of, and this is part of a longer evolution of hospital cases where if you go back 20, 30 years, the hospital decisions focused more on patient behavior and what was called the Elzinga-Hogarty test. And that has been pretty roundly repudiated, both in the Commission's Evanston decision and then more recently in the Advocate and Hershey decisions in the Seventh and Third Circuits, respectively. The judge here in Jefferson criticized the government's use of patient diversion analysis. This is an econometric analysis of where patients go for care and of a model of patient choice, and said, look, I'm supposed to, the court was saying, look, the Hershey opinion is telling me I'm supposed to focus on insurer behavior, and the government's here telling me about patient behavior. That's not relevant unless there's a direct connection to insurer behavior. And I think, again, setting the fact-specific aspects of Jefferson aside, I think it's important to remember that the patient behavior remains very relevant, and diversion analysis is very informative to insurer behavior, because insurers themselves, they're a very important part of this puzzle and a very important aspect of evaluating competition, but they are not themselves consumers of healthcare. They are acting on behalf of their members, who end up being the patients. And in my mind, diversion analysis really answers the key question that any insurer is asking themselves when they sit down to negotiate rates with a hospital or negotiate a contract with a hospital, which is, where are my members going to go for care? Now, they may or may not have the actual econometric diversion analysis that we have from an expert economist, but they have a very strong sense of that, and they're certainly negotiating essentially on that basis. So it'll be interesting to see how that evolves, that push and pull between insurer behavior and patient behavior. And I agree with Norm about the difficulty of geographic market definition in an urban area. Anytime you're dealing with an urban area and you're trying to define a market that is a small slice of that area, it can be difficult for a generalist judge. And I do think he struggled with the idea that there should be an antitrust market that's carved out that has of this urban area where there are probably dozens of hospitals within relatively close distance of that market. That said, the economic literature is pretty clear that a merger of close competitors, even in an urban area, can lead to anti-competitive price increases. And we saw that in one of the first hospital merger cases of what I'd consider the new era, the Evanston case in Chicago. And that was a case of about a consummated merger where we already saw price increases. So that part was pretty clear. But look, it was certainly a disappointing result in Jefferson. But I remain incredibly proud of the hard work of the FTC's litigation team, and really grateful for our partnership with the Pennsylvania Attorney General. We worked really well together. They have a great staff there, and I think there have been and there will continue to be conversations about the strategy and the approach that we used in Jefferson that we'll use going forward. But as Norm suggested, and I said earlier, I can't see this decision dampening our enforcement in any way.
Absolutely. I think it would be impossible to deny that the FTC's hospital merger enforcement program is one of the flagship successes of federal antitrust enforcement in the last 50 years. But let's go to Scott now, who may have a different perspective.
Yeah, I wouldn't say I have a different perspective, but let me just sort of build on a couple of things that were said. As you know, it sounds like there's two different kinds of testimony here that was emphasized and considered by the judge, from insurers and from economists. So maybe just a brief point about each of them. Now, the insurers are, of course, really important in thinking about a hospital merger, because you've got this tussle between the hospitals on the one hand and the insurers on the other about how large the reimbursement will be. It sounds like one thing that was kind of important and maybe a little bit special was just how powerful the payer was here, or at least one of them. I want to say it was IBC, though I might have the details wrong. And that when you have a situation like that, it's a kind of narcotic for the judge to some degree. The judge feels that, you know, well, maybe the testimony can be discounted because the insurer has interests that are not just related to the concerns about higher prices, and maybe their power is going to tend to have the effect of enabling the insurer, at least that insurer, to resist the price increases we might otherwise expect from an increased concentration on the provider side. In any event, it's at least a signal that in future transactions, we're going to have to pay a lot of attention to at least situations where you have one or maybe a pair of unusually powerful payers. I'm more interested actually in the second point, though, about economists. Thinking about this as an economist, I think an economic expert has two worries. One is that they're ignored entirely by the judge, and then the other is that they're taken almost too seriously, as though they have some kind of magic power that if only they could be persuaded to bring to bear in a particular case would clarify everything. Sometimes this has been described in the antitrust community as a kind of CSI effect, that in one particular transaction, the data may be imperfect. It may be limited. We might not have a perfect natural experiment where we can see consumers, or even better, insurers reacting in response to some change in entry or exit on the other side of the transaction. Here, the FTC in some cases has been blessed with extremely good data that they could make use of. I want to say even in maybe an earlier transaction in Pennsylvania. But when you don't have those to bring to bear, you're left falling onto imperfect data, simpler data, could be incomplete data, and might even be basic theory about what you expect when competitors get together. And in those situations, I think it's a toss-up about how judges are going to respond, what they're going to expect. I mean, it seems like in this particular transaction, there was a question about whether, as I think was said, if you know something about how consumers respond, how much does that tell you about how insurers respond? Because at least in principle, the insurers, might not behave in the same way that consumers would in terms of their preferences. From a standpoint of economic theory, though, you would expect there to be a pretty close connection. And so there could be a slippage that results between what the economist thinks is enough to kind of establish a proposition and what may be fully persuasive to a judge. So I think of this particular transaction as part of a bigger picture in antitrust these days, in trying to think about what is the role of economic testimony, how much can we expect from them, how does it fit together with non-economic testimony, and trying to sort out what's happening as a predictive matter. One just further thought on this is, to the extent that it makes enforcers reluctant to jump in ex ante to challenge transactions that are on the bubble or have challenging facts, it may, rather than lead to non-enforcement, lead to ex post challenges to consummated mergers, whereas we know there could be evidence of price rises after the fact. So, for those who throw sand in the gears to make these challenges harder to bring, be careful what you wish for, because you could find yourself on the other side defending a consummated merger rather than trying to work things out ex ante.
Scott, you mentioned consummated mergers, and obviously more generally, challenges to consummated deals are in the news a lot at the minute, particularly in the tech space, as part of a general kind of hurricane of interest around antitrust issues. Sort of recognizing that relative sort of freedom of the antitrust discussion right now, let me ask you and a couple other of our panelists what might be a slightly quizzical question. If you were given an antitrust magic wand and you could wave the magic wand and work one single change in the interests of healthcare competition or healthcare consumers, what would you do and why?
Well, I mean, there are a lot of targets of opportunity here, so I'm not sure I'm going to pick the single most important one. If I were doing a single thing to improve healthcare competition, it would probably be on scrutiny of pharmaceutical patents, and maybe we'll come back to that later. I'm going to pick something a little bit more idiosyncratic, maybe, in part because I think it's a topic that gets, although it gets some attention within healthcare circles, I think it's still neglected in the big picture, which is to clarify that restraints on competition in healthcare affect not only consumers, but other actors too, particularly on the buy side. So, having just attacked hospitals, maybe I'm going to pour one out in favor of hospitals and providers. Let's think about workers, doctors and nurses, other kinds of healthcare workers who are on the other side of the bargain when payers are pushing for as low a reimbursement as possible. And so one thing we need to think about when we're faced with whether it's a merger of insurers, we've had a few of these in recent years, or conspiracies by competing insurers. So the Blue Cross Blue Shield litigation you could think of as implicating this. We might care a lot about what happens to the trading partners of the firms alleged to be engaged in unlawful conduct. So the concern here is that when insurance companies get together, they can reduce competition in reimbursing the services of healthcare providers. So just a couple words on this. The loss of that competition is, I think, sometimes defended on the ground that squeezing providers is a good thing, right? Ultimately helps purchasers, provided there's some kind of pass-through to the consumers. Now, in practice, it often doesn't work that way. In your standard, so we're talking about monopsony, right? So buy-side distortions of competition rather than the monopoly sell side that we normally think about. One of the implications of basic theory of monopsony is that when you cut back on input purchases in order to drive that price down, you're also going to see some effects in the output market that you're not going to like. Not always, but under pretty broad circumstances, harms on the buy side are also going to harm sellers as the firms adjust their output in light of the reduced input. But there's a second point here that I think is more basic and also really important, which is that the concerns on the buy side about healthcare concentration are not limited to their effects on consumers. I mean, we often say antitrust is a consumer welfare statute, which is sometimes misunderstood to imply that we don't care about the buy side. But of course, a conspiracy, price fixing, bid rigging that harms, that harms sellers is also deeply problematic and will send people to jail. Antitrust has always been interested in the sell side as well as the buy side. So one of the things I think we need to keep in mind as a core concern when we think about healthcare consolidation is that when folks get together to harm sellers, when they conspire or merge in order to harm sellers, this is something for us to care about. That that just as when we worry about hospitals getting together to improve their bargaining power vis-a-vis insurers, when insurers get together to increase their bargaining power vis-a-vis hospitals, that is a symmetric concern that we ought to also be deeply worried about. And we see this reflected in some of the case law and some of the cases that have been brought. But I think there's a lot more that could be done here to really bring that to full fruition.
Thank you, Scott. All right, let me offer my antitrust magic wand now to Evan.
So thank you, Daniel. I'd like to focus on an issue that is, I think, quite related to some of the comments that Scott just made. And that is, and Scott and I were involved in a different lawsuit that involved a different industry where this issue came up. And it's the question of two-sided markets. in my view, and I'm sure reasonable people could differ about that, and maybe people on this panel differ about it, but I believe that the healthcare insurance business is in fact a two-sided platform. They have two cohorts of customers. They have the subscribers on one side, and they have the providers on the other side. And traditionally, all of the issues we've been talking about up until now have been looked at through the lens of traditional one-side distribution markets. So when hospital mergers are looked at, it's typically a question of whether increased concentration of providers in a particular geographic market will have an adverse impact or what impact it'll have on reimbursement rates. But there is an other side to that market who are the consumers, the subscribers. And I don't think it's subject to any serious debate that there is a linkage between the premiums that the subscribers pay on the one hand and the reimbursement rates that the providers receive on the other hand. And there are indirect network effects that characterize the market in which insurers sit as intermediaries between the subscribers and the providers. There's no question that providers want to be involved with insurance platforms that have a large number of subscribers associated with them. And there's no question that subscribers want to be insured by companies that have a large supply of providers to offer them. So I think if I were waving a magic wand, I'd be saying that many of these issues should be analyzed through the lens of a two-sided market, which has not really been done heretofore, and look at the effect of on competition in the market as a whole. The market being properly defined as a market in which these two cohorts of customers, the providers and the subscribers, are intermediated by and large by insurance providers, and look at the impact on the competition on both sets of customers or consumers that a particular merger may have, or for example, the enforcement of patents, to go back to something that Robin said at the beginning, may have. But many of these decisions, I think, need to be analyzed through the lens of a two-sided market, and you may get different outcomes when you do that from the outcome that would be suggested by a more traditional one-sided platform analysis.
That's a fascinating argument, Evan. I've spent a lot of time thinking about platforms and I haven't heard that before. That's just a fascinating set of ideas. Let's offer the wand now to Robin.
Thank you. I love the concept of a magic wand, which is marvelous. I wish I actually had one. I am mindful of our time, however, so I'm wondering if perhaps we should move on to the next. I'll leave that to you, but I'm happy to yield my wand to those who've come before.
All right, well, then this is a good moment for me to read out the CLE code. It is CCJ, as in Center for Civil Justice, then AT, as in Antitrust, 21. So that's CCJ AT 21. And mindful of the time, then just as Robin suggests, let's talk a little bit about pharma. So obviously pharma is kind of always on the, if not at the center of the healthcare antitrust radar, particularly at the minute. The FTC has announced this sort of multilateral group to think again about how we approach pharmaceutical mergers. We hear often, Robin, that we are thinking about, we, the antitrust community writ large, think about pharmaceutical competition too narrowly, and that we should, kind of think more flexibly, set aside some traditional, maybe market-bound conceptions of the way that competition in pharma works. Let me start by asking you, do we need to change the ways that we think about pharmaceutical competition? Are there plausible alternatives that we should explore?
In my view, modern antitrust law has become increasingly atomistic, with courts focusing on individual points of behavior rather than considering the comprehensive effects of the business behavior. That atomistic approach leaves antitrust law ill-equipped to handle a range of the modern behaviors that we are seeing in pharmaceutical competition. That focus is misplaced. Companies and markets don't focus on one particular act to the exclusion of all else. Business strategy emphasizes holistic, integrated planning, and market outcomes aren't determined by a single act, but by the result of multiple acts in the overall context and structure and characteristics of the market. So the atomistic nature of antitrust law causes us to miss two important classes of potential competitive harms. First, the focus on individual acts means antitrust law can't effectively deal with what one might call probabilistic competitive harm. That is, multiple acts, any one of which might or might not harm competition. So, for example, if a dominant firm buys 100 companies, the probability of any one acquisition harming competition is often below 51%, but the likelihood that a pattern of acquisitions might harm competition much greater. Second, an atomistic antitrust approach tends to miss what I call synergistic competitive harms. That is, acts that are lawful when taken individually, but that combine together in an anti-competitive manner. So unfortunately, modern antitrust law has strayed too far down this individual atomistic pathway, and courts take too narrow and transaction-specific focus. So instead of asking, is the overall behavior of this company reducing competition in the market, they focus on a particular merger or a challenged monopolistic practice in isolation. So consider the recent decision in re Humira in the Northern District of Illinois, and it's on appeal now. Plaintiffs alleged a variety of anti-competitive activities related to the drug I think most people have heard of. It's a blockbuster rheumatoid arthritis drug, Humira. In the section of the court's opinion that considered the company's patenting behavior, the court found the following facts. So the company filed a total of 247 patent applications. That's a lot. And they obtained 132 patents. 90% of those patents issued more than 12 years after the drug was first marketed. And looking at those facts, the court rejected any allocations of anti-competitive behavior, saying the company's, quote, batting average precluded any antitrust violation. In other words, the company lost 47% of its patent filings, and the court said, well, they got a bunch of them, good enough. And the court went on and then listed the percentage of successful actions by companies in similar antitrust cases, as if counting up the number of times you succeeded versus the number of times you failed could provide a concrete answer, maybe a magic wand, regarding the behavior as a whole. And then, of course, the court looked at the patent filings somewhat in isolation rather than in the context of all of the company's behaviors that were alleged. So this type of approach just entirely misses the point of synergistic behavior, how things move together. I like to say one cannot understand the power of a symphony by counting the notes. So in my view, modern antitrust needs to find a better framework for integrated analyses in which individual actions are understood not on their own, but as part of the comprehensive whole. That's where I think we fail.
That's a wonderful way to put it. Evan, do you agree? Do we need to be drawing together disparate sort of dimensions of an overall anti-competitive scheme in ways the courts haven't been doing? Or is there some other kind of drastic change in our approach to pharmaceutical competition that's overdue?
Well, I would offer a somewhat different perspective from what Robin just said. And in addition to that, I want to make one other point about innovation in the pharmaceutical industry. First of all, with respect to the patent point, I mean, there is, I believe, a reason why the antitrust laws interact with the patent laws in the way in which they do and the way in which the courts have evolved that jurisprudence. And that's because we have an institution, the Patent and Trademark Office, which is charged with the responsibility of deciding which applications get through that bureaucratic filter and result in patent grants of exclusivity and which do not. And that comes with a legal presumption that the patent is in fact valid unless clear and convincing evidence is provided to a finder of fact to overcome that presumption of validity. So I don't find the same fault or sinister motive with the batting average approach that Robin was suggesting, because the fact remains that in 50% of the instances in which that company, I assume it's AbbVie, filed for patent applications, The patent office, in its discretion, decided to grant those patents, and that gave them a legal presumption of validity that entitled them to exclusivity unless and until they either licensed the patent or a trier of fact finds by clear and convincing evidence that the patent shouldn't have been granted in the first place. So the ability to obtain patents is an enormous incentive to innovation. And if we've ever had a moment in our history when the innovative capability of the pharmaceutical industry has been more important than it is right now, I would challenge someone to tell me when that is, given the miracle of development of several remarkably effective, remarkably safe vaccines for this horrible worldwide pandemic that we're suffering under. The fact that that industry was able to develop those vaccines in that period of time with those results is remarkable. So I would argue that doing what we can to protect innovation and not doing any violence to the existing rules of how the patent or intellectual property sector interfaces with the antitrust sector, not doing any violence to that relationship would be well advised at this point, which relates to my related point, which is I've found, and I've represented a lot of, by way of full disclosure and concession, I've represented a lot of pharmaceutical companies and a lot of courts for many years. And one of the things that I find is often either overlooked or deliberately disregarded is the economics of innovation. Pharmaceutical companies, in some respects, are very much like software companies, meaning that they encounter huge upfront sunk costs. But once those costs are invested, the result of that process is a situation in which the marginal costs are nominal. And if you don't analyze it properly, you can easily be led into the conclusion that the returns on those marginal costs are enormous, exorbitant, too high. But in fact, the overwhelming proportion of bench starts of R&D programs in the pharmaceutical industry fail. There's never a nickel of revenue recovered against all of those costs. So the cost recovery, by definition, takes place against only that small percentage of cases that are successful and lead to successfully introduced drugs that get through the FDA process, et cetera. And we need to keep that in mind, because if we don't have adequate incentives to drive the enormous sunk cost investments, often never recovered through successful products, we're going to deter innovation. And that's going to result in situations where we don't have the kind of miracle that we've all experienced in the last 12 months with respect to the vaccines. So I view these as two parts of a common issue. We should not do any violence to the patent system and the patent office's discretion to decide which inventions are sufficiently innovative to merit exclusivity through a patent and which aren't. We should respect the dividing line between that jurisprudence and the antitrust jurisprudence, which is admittedly in tension with it, but they have successfully coexisted for well over 100 years. And we should keep in mind the cost structure of the pharma industry and the difference between enormous sunk costs that are often not recovered and the marginal costs, which are nominal, of the successful cases, and not view that as a distortive effect that looks at it as if there were exorbitant returns on those costs.
Thanks, Evan. I want to make sure others have an opportunity to react. I know someone who spent a lot of time thinking about the IP antitrust interfaces. Scott, you want to jump in?
Yeah, sure. So by way of preface, I am definitely pro-innovation and I am pro-vaccine. And so nothing I'm about to say should be taken as in any way contrary to that. And I think we should absolutely have a dividing line between antitrust and IP, and we should, respect that and stay in our lane as best we can. And the last thing I'll say is about staying in the lane.
I think you're a butt coming.
There's a but. Maybe there's a couple buts. Two buts and an and. So one of the buts is that we could all agree that some patent is valid and yet it not be infringed. And so whenever we think about the exertion of a patent to try to block, whether it's a generic or a biosimilar or something else, half the story, sometimes more than half the story, is the non-infringement question. And whatever we think the presumption of validity means in the real world that attaches when a patent issues, it doesn't have anything to do with infringement. And so a lot of these cases get fought on non-infringement grounds. The other sort of but here is that if we put to one side, let's divide the world into two kinds of patents, as I and a co-author have done a few times. We've got active ingredient patents, which sort of cover the novel substance, and then we got everything else. I'm going to call them secondary patents. Active ingredient patents, When those get litigated to conclusion, the brand usually wins. Great. God bless them. As it should be, it is part of the vouchsafe of profits that help fuel innovation, and we should love that. But when we look at these secondary patents, there's often a whole bunch of them. They're often late issued. Most of those go to the alleged infringer. That is, the brand loses most of those. So that might suggest to us that the PTO issuance process is not a complete account of whether patents are likely to be found valid and infringed. And some of those are infringement cases, and some of those are just cases that end up with an invalidity judgment. So those are my two sort of buts. The and this comes back to the thing that I would really do if I had a wand, would be to get into that wheelhouse that Evan, I think, correctly identifies, right? To do something not within antitrust, but internal to the patent system, which is take more seriously the review process when we get these patents issued in the first place. I think it's a travesty that we don't spend, I'm going to say all the money in the world, but I really mean just a couple of $1 million to work out whether a given patent on a Humira or on a Lipitor ought to be issued. I mean, I think it's shocking that sometimes we find out 5, 6, 8 years later that this duly issued patent doesn't really do anything in the world in terms of blocking generics, except for the fact that litigating the case itself blocked generics. And so I think with a modest redeployment of resources, we could, especially in pharma, we're only talking about a couple thousand patents in the entire Orange Book, right? The Orange Book, on which the pertinent patents on small molecule drugs is listed. Couple $1 million, we'd probably get rid of some patents that shouldn't have issued, but we would go far to making the reality of patent issuance live up to the promise that Evan just articulated. So I think we could all agree that doing that as vigorously as possible is something that we ought to all be in favor of.
Thank you, Scott. So we have somewhere between 5 and 10 minutes left, which I think leaves us time to talk about one more thing. And I want to do it by bringing in something that was touched on a little bit earlier when we were talking about Jefferson Einstein, and that is the role of state attorneys general. So we have not only 2 federal antitrust enforcers, but also an increasingly prominent constellation of state AGs, some of whom have been very visible and active, not just recently, although certainly that is part of the recent tech cases, but for a long time in some cases. So how does our panel see the role of state AGs in the healthcare space, and what can be done, recognizing that they're often working with constrained resources? What can be done to support them? Let's start with Norm.
Yeah, I want to come at it from Daniel, from the merger side of things. As I mentioned before, I do think they have a significant role in healthcare, and particularly in transactions that have a local aspect to them, like we were talking about a minute ago, Jefferson Einstein. Again, and how visible and how involved they are, it really depends on each state, and they're, each state has different resources. Some of the larger ones are more involved than the others. But as I mentioned before, in the hospital context, right, when, we'll back up, when I was at the agency and looking at hospital transactions, we were very concerned that hospitals could easily get community support, right? I mean, they have boards that are made up of community leaders. They're going to be able to get support, and we could get hometown, basically, and the judge would say, look, great, FTC coming in here, you're going to tell me what to do, but I'm talking to the business leaders of the community here telling me this is a great deal. So one way of that we thought back then was to counteract that, was to have the AG, right? I mean, and the entity that sort of represents the citizens of the state being able to go into court and saying this is a bad thing has a significant influence on the judge. And so, it does have a significant, I think, role, at least on the transactional side of things. And so, again, as I mentioned before, clients often ask that specific question, how can we sort of either win this litigation, or how can we convince the agency, the FTC to go away? One way is obviously the AG. And if you can get the AG to be on your side and support of your transaction, I think it's unlikely the agency is going to really challenge it. That doesn't mean that they wouldn't in this new administration challenge things, but if you look historically, in almost every single hospital merger challenge, the AG was there, right? With the FTC sitting there in the litigation. So for me, I do think they play a pretty significant role in merger enforcement.
Mark, what's the view from the federal agencies?
Yeah, so I think Norm's recollection of his view when he was at the agency is similar to how we see it now, and certainly the AGs are an important partner. Certainly at the investigation stage. Anytime we're just looking at a merger, we want to work with the AG. It's important to have their perspective, and a lot of times, as I said before, healthcare markets are complex, and particularly local healthcare markets are complex. They have a lot of history to them. AGs can be very helpful in helping us to understand how things ended up the way they are, and really helping with the narrative. And they're certainly helpful in the way that Norm mentioned, in terms of going into court and demonstrating to the judge that this isn't just DC in law enforcement swooping into a local hospital situation and trying to dictate an outcome to the local community. It's really the local law enforcement is there sitting right next to us. I think one of the big questions that's come up recently is, given that there are so many healthcare transactions, and a lot of them are small, it doesn't mean that those small transactions can be harmful. We're talking about small physician deals or even small hospital deals, and then the federal government can't always get to all of them, and can some of that be handled by the states? And we've seen the states look to take on some of those on their own. I think this is a very case-by-case basis, and really state by state. As Norm mentioned, there's a wide variety of resources, different resources among different states, and different interests in antitrust. And I think it's important to reiterate how resource intensive antitrust litigation and merger litigation can be. At the federal level, we have two good-sized agencies that are well-resourced and have a ton of experience focusing on antitrust cases, and it's resource intensive for us. It is a drain on us, it's a significant drain. And when you're talking about a state AG that wears many more hats than just antitrust, asking them to take on a case on their own can be a daunting task. I mean, I think about the Sanford, Mid-Dakota case that the FTC brought about 4 or 5 years ago. And that was a local physician deal in Bismarck, North Dakota. From a market size perspective, it was not the biggest case. From a resource perspective, it was a significant effort from the FTC and from North Dakota. But just because it's a small case doesn't mean it's a small outlay of resources.
Thanks, Mark.
I'd want to jump in there saying, Dan, too. I mean, I agree with Mark in some respects in terms of there's several healthcare transactions that just don't hit the HSR threshold, right? In a lot of these rural places, and the FTC won't even know about it, right? I mean, and so in addition, even if they did know about it, I'm not sure they have the resources to go after them. You have to we used to call it triage. Really look to see kind of which cases you're going to invest the resources in. Usually, it's those that have the most impact on consumers, and so some of the smaller transactions are going to happen. There will be roll-up acquisitions in rural places. And that's where I think the states can be very helpful. I mean, obviously, they're local in nature, and the states can kind of handle that to alleviate some of the stress on the resources at the federal level.
Totally agree. I think before it's anything else, antitrust enforcement is an exercise in allocation of very scarce resources. Robin, with just a minute or so left, the last word is yours.
Oh, that's wonderful. I get a magic wand and a last word. So the last word I would say is, at the end of the day, we should be thinking about patients. We should be thinking about the effects on what they experience each day, on their access to healthcare and their access to medicines. It is so easy to get lost, with great due respect to the economists and to Scott, in the economics, and to forget that we have to step back and think about the real people on the ground. That, I think, is an important perspective for antitrust to hold on to.
What a perfect note to end on. We started with thinking about the things outside antitrust. We ended with the very core of antitrust, consumer welfare and consumer well-being. If we were all together in person, I would ask the audience to join me in thanking our wonderful panel. This has been a terrific discussion. And it's my pleasure now to thank this group and to hand the baton back to David.
I have, before we finish, I want to thank the panelists for their presentation and insightful comments. I thought it was a very spirited and, as I said, insightful presentation. And a special thanks to Cravath for their really wonderful partnership throughout this 4-part series. Tomorrow, please look for an email from the center, which will include a form that you will need to fill out for CLE credit. Thanks for joining us, and I hope you enjoy the event.
Thank you.
You.